Hello, everyone, and welcome to Uncivil Law. I hope you're having a great day as always. And we are here with the United States Supreme Court decision from Friday dealing with immigration law and asylum seekers and the due process they do or do not have to be given. This is the case of United States of America versus Thuraissigiam. We're going to call him Thur. This is Department of Homeland Security versus Thur. In this case, Mr. Thur is from Sri Lanka and he came here illegally and he was detained 25 yards after crossing the border. So he didn't make it very far. And he was given an expedited deportation hearing and was not allowed to see an Article 3 judge. So he's allowed to see an immigration judge, but not a federally appointed judge in terms of the judiciary. So we're going to read this 7-2 decision. We're going to read the syllabus to start with, and then we will read some of the majority opinion, probably just skip around a little bit to see what's going on. So let's get started with this. So yeah, this is Department of Homeland Security versus Thur. I apologize to Thur, but yeah. The Illegal Immigration Reform and Immigration Responsibility Act, IRA, Congress wasn't able to come up with a nice sounding acronym, I guess, provides for expedited removal of certain applicants seeking admission into the United States, whether at a designated port of entry or elsewhere. So a designated port of entry would be where there's a border guard station. A non-designated port of entry would be literally all the other places. An applicant may avoid an expedited removal by demonstrating to an asylum officer a, quote, credible fear of persecution, defined as a significant possibility that the alien could establish a claim for asylum. So you can be removed on an expedited proceeding, but you can avoid it if you can establish this credible fear determination. An appellant who makes this showing is entitled to full consideration of the asylum claim in a standard removal hearing. So we have a two-step process. We have this initial immigration officer who's an executive branch official. So it's a person working for immigration, and they have to make an initial determination as to whether or not it's credible. And if it's credible, then they're entitled to a hearing. So that's the two-step process that we have. But the law limits the review that a federal court may conduct on a petition for a writ of habeas corpus. In particular, courts may not review determination that an appellant lacks a credible fear of persecution. So Congress, when it passed this law, said that there were some procedural things that they could and could not do. And one of the things they could not do is try to get at this from a habeas petition. And this is not, incidentally, the first time Congress has tried to legislate around the habeas petition. The other one that's the big one of note, that's not really relevant here, but it's the other statute that's notable, is the Effective Death Penalty Act. I think it's called AEDA because it's Effective Execution of Death Penalty Act or something like that. But basically that also constrains the use of habeas petitions in death penalty cases, because in death penalty cases, people are using habeas petitions to just keep getting bite after bite after bite after bite on the apple. And Congress said, no, there is a finality to this. And so there is still review, but there's a cutoff. And so somewhat similar here. There's a review process, but there's a cutoff. So they're kind of comparable in that way, I guess. Respondent Thur is a Sri Lankan national who was stopped just 25 yards after crossing the southern border without inspection or an entry document, so no passport. He was detained for an expedited removal, so we're going to kick him out right away. An asylum officer rejected his credible fear claim. A supervising official agreed, and the immigration judge affirmed. So there was a process of review. The person reviewed it, said no. His supervisor said no, and the immigration judge said no. So they all said no, this guy does not have a credible fear. And they're all trying to make this initial determination on the basis that a lot of these people have been coached and have been taught magic words. And so they're trying to make a determination not based on only the words that are used, but based on a whole holistic assessment. And so there is an expedited process to deal with that, because we are under the belief that some people may claim asylum when they don't really have asylum because they might believe it might extend their stay. So we're trying to get out people who are trying to claim asylum fraudulently, merely to extend a process that they shouldn't be having in the first place. The respondent then filed this habeas petition, asserting for the first time a fear of persecution based on his Tamale ethnicity and political views, and requesting an opportunity to apply for asylum. The district court dismissed the petition, but the Ninth Circuit reversed, because of course they did, holding that, as it applies here, the law violates the suspension clause and due process clause. So the suspension clause says habeas corpus may not be suspended except in due process you all know and love. All right, so let's go over what's going on here. Held. As applied here, the law does not violate the suspension clause. The suspension clause provides that the privileges of the writ of habeas corpus shall not be suspended, unless, where in cases of rebellion or invasion, the public safety may require it. This court has held that at a minimum, the clause protects the writ as it existed in 1789. So we're going to originalism. What did it mean? Because this is sometimes considered the Great Writ. It has a history. So what did it protect in 1789 when the Constitution was adopted? Habeas has traditionally provided a means to seek release from an unlawful detention. Respondent does not seek release from custody. We're happy to release you from custody. We want to deport you. So we have no desire to keep you in custody. We'd like to send you back to your home country. So yeah, we're not trying to keep you in custody. We're trying to do very the opposite of those things. So yeah, we're not trying to, so he's not saying, let me out of jail, because the government doesn't want to keep him in jail. They want to send him back to Sri Lanka. So respondent does not seek release from custody, but he instead seeks an additional opportunity to obtain asylum. His claims therefore fall outside the writ as it existed when the Constitution was adopted. Yeah, so this to me seems pretty easy. The writ of habeas corpus literally means produce the body. And what it means is, please justify why I'm being held. Why am I being detained? What is the lawful basis of being detained? That's the writ of habeas corpus. So if you're put in jail for no reason, the writ of habeas corpus is your relief. And if the reasons that are holding you aren't good enough, that might be your relief. And as I mentioned, Congress has legislated around this, particularly when it comes to the death penalty, because people were using it as an abusive mechanism. But it's a please justify why I'm being held in jail. And here they don't want to hold him in jail. They don't want to detain him. They want to make him go away. So yeah, we're not interested in detaining you. We're very much interested in specifically not detaining you. So seems very originalist to me. This is not what the writ of habeas corpus had in mind. So the respondent, Mr. Thur, contends that there are three bodies of case law that supports his argument that the suspension clause guarantees a broader habeas right, but none do so. So he says there's some case law on this. Okay. Respondent first points to British and American cases decided before or around the Constitution's adoption. Good idea. All those cases shows that habeas was used to seek release from detention in a variety of circumstances. Fair. Respondent argues that some of these cases show aliens using habeas to remain in the country, but the relief ordered in those cases was simply a release. An alien's petitioner's ability to remain in the country was due to immigration law or lack thereof. The relief the habeas court may order and the collateral consequences are two entirely different things. So what they're pointing out here is, yes, there were a lot of old cases when our country was first founded and our immigration laws were not particularly well defined. And so there were cases with aliens who were being held for whatever, and they had a habeas petition and said, please let me out of jail. And the court said, okay, we'll let you out of jail. Now, because our immigration law is not particularly well defined at this point of history, the collateral consequence of that is, yes, you get to stay in the United States because our immigration law is not particularly well defined. But the court didn't say, yes, you get to stay in the country. What the court said was, yes, you get to not be in jail. So what the court ordered is, you don't get to be in jail anymore. That's great. A collateral consequence of that, you get to stay in the country, was not what the court was talking about. It wasn't what it was talking about in 1789. It's not talking about it now. So what habeas can do is say, yes, you don't get to be in jail anymore. We will let you go of jail. What the collateral consequences of that are a whole nother story. And our immigration laws become a little bit tighter today than it was in 1789. Although respondent claims to rely on the writ as it existed in 1799, his argument focuses on court's decision during the Finality era, which takes its name from the feature of the Immigration Act of 1891, making certain immigration decisions final. Yeah, some decisions, we have to have a point of finality. When do things become final? That's fine. In a prior case, in Echo versus United States, this court interpreted the act to preclude judicial review only of questions of fact, which is pretty fair. Appellate courts don't typically review questions of fact. So the idea that the judicial body wouldn't necessarily have the ability to determine facts, that isn't like necessarily a wholly strange idea. Executive agencies determine facts all the time, and so the judicial branch can adjudicate based on those facts. That's fine. The federal courts otherwise retained authority under Habeas Act of 1867 to determine whether an alien was detained in violation of the federal law. Thus, when aliens sought habeas relief during the finality era, the court exercised its habeas jurisdiction that was conferred by the habeas statute, not because it was required by the suspension clause, which the court did not mention. So at the time, there was a statute dealing with habeas. And so at the time, the court granted relief under the statute. Now, statutes can always go farther than the constitutional minimum. So the idea that there was a statute called the habeas statute, and the idea that that might provide you some kind of relief under the statute, that's a wholly different question, right? If we're interpreting a statute, we're interpreting a statute, and Congress can change its mind. And Congress can always give more than the Constitution demands. But here we're not asking statutory questions. We're not asking, what does a habeas act say? We're asking, what does the habeas clause of the Constitution say? What does it require? Congress can go further, but they don't have to. And here they specifically decided not to want to go further. They were trying to constrain this. So what Congress might have provided for in the 19th century in some habeas act, that's super duper interesting and all, but not really material to our purposes. That makes total sense. The court's more recent decisions in Bodemine versus Bush and St. I guess that's Croix, also do not support respondents' argument. Bodemine was not about immigration at all, and St. Croix reaffirmed the common law habeas writ provided a vehicle to challenge detention and could be invoked by aliens already in the country who were held in custody pending deportation. It did not approve of respondents' very different attempt of the use. So yes, so St. Croix reaffirmed the common law habeas writ provided a vehicle to challenge the detention. And that's all. That's all we're trying to do is challenge detention. Why am I being detained? We don't want to detain you. We want to make you go away. Yeah. As applied here, the statute does not violate the due process clause. So we've moved past the habeas petition, right? So we move past the idea of habeas corpus. What does habeas corpus do? It says, why am I being detained? The government says, we don't want to detain you. Okay, that's kind of the end of that analysis. But maybe there's a due process issue because the government wants to do something and they have to give you some kind of process. Now, what kind of process that is can depend quite a lot depending on the situation. So it obviously varies. But here they're saying, well, maybe we didn't give you enough due process. Okay, well, did we or didn't we? All right, let's find out. As applied here, the statute does not violate due process. More than a century of precedent establishes that for aliens seeking an initial entry, so your first time coming in, the decisions of the executive or the administrative officers acting within the powers expressly conferred by Congress are due process of law. So, yeah, we have oodles and oodles of precedent on this. Congress gets quite a lot of latitude when it comes to immigration authority. They can do some things that they can't do anywhere else when it comes to immigration. And so the idea that Congress said, okay, we're going to give this power to the executive and that's kind of the end of the ball game. Congress has so much latitude when it comes to immigration authority that's probably enough in and of itself. Like if they were dealing with a U.S. citizen or a green card holder or something, the idea a executive may be able to do things might be concerning. But when it comes to immigration authority, the power of Congress is pretty broad. And so they say, well, we just want to give this to an executive and let them do it. The courts say that's fine by us because when it comes to Congress and immigration, Congress has lots of power. There's lots of power to determine because it's one of those like fundamental rights of sovereignty. It's pretty hard baked into the concept of sovereignty. It's hard baked into the concept of what a country is, for that matter. If you look to an international law and what are the definitions of a country? Well, a border, a population, and the ability to control like who does and does not come into those boundaries. So the idea of being able to control the borders goes pretty far baked into the concept of a sovereign entity. So the idea of the sovereign being able to exclude pretty much anyone for pretty much any reason or no reason at all. It may be one of the very few times that government can act arbitrarily. I don't know about that. Arbitrary and capricious is a whole nother thing. But I'm just trying to give you an idea of how expansive the power is when it comes to immigration. Congress can go pretty far. If Congress wanted to only let in members of certain religions, for example, and not let in members of other religions, the courts would have to think about it for a little bit. That's how expansive it is. It may be what we call a what is the term for it? It's called a when one branch has total power. It's called a I can't quite remember, but basically a unitary power. Basically, they can do whatever the heck they want. So there might be absolutely no limits, and if there are limits, they're very tight. But yeah, so Congress might be able to do things in this domain they can't do anywhere else. Respondents argue the rule does not apply to him because he succeeded in making it 25 yards into the territory. So his claim is, oh, but I made it 25 yards, which is 75 feet. And a yard is roughly a meter. And it's not exact, but close enough for our purposes. So that's 25 meters for those of you acting at home. So, not really very far. The rule would be meaningless if it became inoperative as soon as an arriving alien set forth on the United States. Yeah, we're not doing a feet dry thing. No. An alien who is detained shortly after unlawful entry cannot be said to have effected an entry. Yeah. An alien in response position, therefore, has only the rights regarding admission that Congress has provided by statute. In respondent's case, Congress has provided the right to determination whether he has a significant possibility of establishing asylum, and he was given that right, reversed and remanded by Alito writing for a whole bunch of people. So that was super duper interesting. So yeah, that makes total sense as basics of immigration law 101. So for the TLDR, for the people who want to turn away, yeah, if you are an illegal immigrant and they catch you at least within a reasonable distance of the border, then you don't get a habeas petition. And obviously, the Supreme Court's not going to have to decide more than they have to, but they probably can do it even past that point. So, as long as they catch you, probably anytime they can do this, or at least Congress can, to more report properly. You have to put to exactly what Congress does and does not allow for, because Congress gets a lot of latitude. And if they want to give that power to the executive, well, that's fine too. All right, so I think I'm going to just skim a little bit through the majority opinion. I'm not going to read it, but I'm just going to skim and see if there's anything that I want to talk about in a sort of detail, because the majority opinion is 36 pages, and so I'm just going to really speed read it real fast and see if there's anything here that I want to talk about. So let's see. Yeah, we're talking about the history of how it came to place. So we're talking about the history, we're talking about the process. So, and then this is a little bit interesting factoid. Over the last 5 years, 77% of screenings have resulted in finding a credible fear. And nearly half the remainder were closed for administrative reasons, including the alien's withdrawal. So apparently we're giving these things out pretty broadly in general. And presumably the Trump administration could make it harder to make the credible fear by executive order. So, but President Trump has been president for pretty much most of the last 5 years. So, that's pretty relevant. So it's not like we're just denying these things willy-nilly. So let's see. Limits the review of habeas. A majority objective was to protect the executive discretion from undue influence by the courts. Yep, that makes sense. The questions presented thus have significant consequences for immigration if courts must review credible fears. Then expedited removal would burden the system. Yeah, that too. So it's like if we let this in the courts, man, we'd be doing nothing else, right? So there's also that factor too. So we talk a little bit about the history of how it came to be. We talk a little bit about the suspension clause. We cite some Blackstone, a satisfactory exposition of common law. Habeas was meant to remove an unjust and illegal confinement. Yeah, pretty much. So we're trying to get you off confinement. That's what that is. So the Ninth Circuit is off the reservation because the Ninth Circuit is going to Ninth Circuit. Yeah. Like the habeas petition in this other case, the respondent does not want simply release, but ultimately to remain in the United States. Yeah, that's a little bit more than what habeas had in mind. That's not what habeas is about. So now we're talking about the case law and our history about the case law. And we talk about the history of these other cases where they were released and allowed to stay, but that was a collateral consequence, not what the judge was ordering. Yeah, and then we talk about some cases in England where the same kind of result occurred. In these cases, it may be the petitioners were able to remain in the United States as collateral, but it was not due to the order of the judge, not due to the habeas order. Blah, blah, blah. Dealing with extraterritoriality. Despite pages of rhetoric, the dissent is unable to cite a single pre-1789 case in which they ordered anything like what was being ordered here. Yeah, that doesn't make sense. That's not what habeas is about, so I wouldn't expect to find one. What the dissent merely implies, arguing the scope of the writ guaranteed may change depending on the circumstances. That's death to conservatives, man. Changing on the circumstances. No, none of those things. And now we talk about the statutory thing that we did. That was good. We talk about the history of how that came into being, the Immigration Act. We talk about some stuff dealing with the interpretations under that act. As the respondent reads it, the court interpreted the 1891 Act to preclude review of all questions related to entitlement. It would find the face of statutory terms, but even if that's true, it's a statutory thing and not relevant to the constitutional holding. Holding an act of Congress unconstitutionally suspends writ of habeas corpus is a big deal. It is a pretty big deal. What else? When we look to these things from this case, any suggestion becomes less plausible. Respondent suggests this could not have applied to factual questions. Yeah. Whether or not the executive gets to determine the facts or not, that's well baked into administrative law. So judges may be able to only review legal findings and not factual findings. That makes sense. Particularly in immigration, as I mentioned, because Congress has so much power when it comes to immigration. We distinguish this case. Okay, then, yeah. And then we talk about the respondent's other cases, this St. Croix, I'm guessing I'm going to pronounce it, when the court's pertinent holding rejects the argument that this provision of this law and the Anti-Terrorism and Effective Death Penalty Act. So, yes, it's the AEDA, Anti-Terrorism and Effective Death Penalty Act. That was the other statute that dealt with habeas. So it totally makes sense to compare those two statutes. I did earlier. So yeah, respondent is also going to compare. He's going to compare this immigration statute to the Anti-Terrorism and Effective Death Penalty Act because both suspend habeas. So yeah, they're comparable. You know, the degree to which one reads on the other is debatable, but they're worthy of being mentioned in the same sentence. And he says the AEDA did not expressly refer to habeas, which is true. It didn't. It just basically did it by effect instead of by words. Violates due process. No. Foreigners 1892, the court wrote that foreigners who have never been naturalized nor acquired any domicile or residence with the United States have not been admitted to the country as a matter of law. Yeah. The decisions of the executive acting within the powers are due process of law. So at least in 1892, people even here who are visiting as tourists apparently have not been admitted to the United States. I don't know if that's true now, but apparently it was true in 1892. So if you come here on a tourist visa, you're not admitted into the United States, even though you're walking around in New York City. At least in 1892, that seems to be true. I don't know if that's true today. The rule does not apply to him because he was not taken into custody the instant he attempted to cross the country. Because he made 25 yards, that's all the difference. Lame. Totally lame. No way. This rule would be meaningless if we did this dry feet thing. Yeah. Unless you're a kid coming over here from Cuba, we don't do the wet foot, dry foot thing anymore. For anyone who knows anything about what I'm talking about, yeah, we're going old school. Wet foot, dry foot in Cuba. Oof. Hello, Elian Gonzalez, right about now, too. Yeah. For these reasons, they have only these rights, and the Ninth Circuit erred, and blah blah blah. All right, so we successfully summarized 36 pages of case, so that was fun. So yeah, that totally makes sense. I totally buy that, and it makes total logical sense. So the Congress has the ability to control immigration. They have the power to put in place rules, and their power is pretty expansive. It may be absolute. It goes pretty far because it goes basically into the depths of what it means to be a sovereign and the ability to exclude people from your borders. So the power of Congress may be absolute. And if it's not, yeah. And anyways, so Congress gave the ability of the executive to make this determination, and they made the determination. That's all the due process you get, and this is definitely not habeas. No. So the due process claim was better than the habeas claim. The habeas claim makes no sense from square one. I mean, it's totally not habeas. So the habeas claim is a total loser for me. The due process claim is a little bit more interesting. But as I point out, because it's immigration, like the due process is like, it's pretty minimal. So we're there. So that was good. Anyways, I hope you liked this thing. For the, how many of you who are currently watching? For the 50 of you who are currently watching the stream, I hope you liked this stream. I hope this was educational. And we got through it in less than 30 minutes, which isn't too bad for a U.S. Supreme Court case. We will be back Monday at 10 a.m. Eastern Time with more stuff. We will live stream and live react, and then we'll try to speed read some decisions. It'll be fun because it's the last day for decisions on the Supreme Court term. So we're expecting all the big stuff to come down Monday. So there will be something dealing with abortion restrictions. There will be something dealing with Trump's tax records. And there will be, where is half of Oklahoma? Where's Tulsa? Yes, we might find out the answer to where's Tulsa on Monday. That'll be fun. So we'll see how that goes. And we'll find all that stuff. So, yeah. As always, I appreciate your like. Of course, we'll also be back tomorrow with our batch record. Normally, we record around 11:30, 12 o'clock. That's Central Time. So we'll be back tomorrow with some batch record, and we'll be out with our normal daily videos. So until later, my friends, I hope you're well. And cheers, and goodbye.